So let's take a look at the executive order itself. What does it provide for and what does it not provide for? First, just a basic civics lesson. As you know, Congress makes the law, the President executes the law, and the courts interpret the laws. And in recent days, these lines have been blurred and sometimes somewhat egregiously so. But that is the way the Constitution is set up. So the three branches of government will be separate and have their own little pieces of the pie, if you will, that they are responsible for. But an executive order is a legally binding order of the President, and it's legally binding to the extent that it directs the executive branch to execute the law. There are parts of an executive order that would not be legally binding, but it is legally binding to the extent provided for under the Constitution. And it typically directs federal agencies how to execute the law. So the part of the executive order that would direct Catherine Sebelius to prepare regulations that would establish ways to keep the funds separate in those plans that include abortion, when the separate premiums are going to be paid for abortion services versus the general health plan, the executive order would be legally binding to the extent it directs the Department of Health and Human Services to do so. The controversy with executive orders is that there's no congressional consent. Congress does not have to consent. The President can sign an executive order without congressional consent. Now, there are constitutional limits to an executive order. So the President executive order, it can't amend or contradict the law. And it also cannot repeal a lawful act of Congress. The President has the veto power to veto a law before it actually goes into effect. But once the law is the law, the executive order cannot repeal the law, and it cannot act as a veto. It also cannot amend or contradict the law. The executive order's stated intent is that no federal dollars will be used for abortions consistent with the prior policy. And the President in the executive order specifically mentions the Hyde Amendment, and it's his intent that the Hyde Amendment remain the law. The problem with that is that it really cannot add the Hyde Amendment to the law because it's an executive order, it's not an act of Congress. The other thing that the executive order states is that it's a statement to establish policies and procedures to achieve the goal of having no federal dollars used to pay for abortions. And it again directs Catherine Sebelius to establish regulations to maintain separate funds for those insurance plans that include abortion coverage. The executive order does not, and it cannot prevent the unrestricted community health center dollars from paying for abortions. It does not provide the missing conscience protections that we discussed earlier, and doesn't even mention anything about conscience protection. It doesn't add the Hyde or Weldon Amendment language to the bill, and it doesn't fix the bill. So the states' rights. What are the states doing in response to this health care bill? Well, the first state to take action was Virginia. The Attorney General there, Ken Cuccinelli, filed a lawsuit addressing really the health insurance mandate. As you recall, in 2014, each American citizen that is over the age of 26 is going to be required to have insurance coverage. Adults under the age of 26 can continue to be covered under their parents' insurance plan, but after that, each individual in the U.S. is going to be required to have insurance for medical care. And this is really an unprecedented act of Congress. Congress has never before mandated that individuals in the U.S. participate in economic activity. And so Attorney General Cuccinelli argued that Congress does not have the power under the Commerce Clause to mandate that individuals in the U.S. purchase insurance. He also argued that the insurance mandate violates state sovereignty under the 10th Amendment. 20 state attorney generals have also filed suit from 20 different states and Pensacola in a federal lawsuit, making the same arguments that were made in Virginia. And Lieutenant Governor Kinder in Missouri filed a similar lawsuit in Cape Girardeau. Chris Koster, who is Missouri's Attorney General, chose not to join in the lawsuit that was filed in Florida. And I'm sure he did so for political reasons, but he also stated that he did not want to use public funds to pay for a lawsuit that he felt would ultimately reach the Supreme Court and be binding on all the states. So he chose not to join in the lawsuit. But Lieutenant Governor Kinder did file his lawsuit in Cape Girardeau, and it's funded with private dollars. And both the lawsuit in Florida and Lieutenant Governor Kinder's lawsuit basically raised the same arguments that were raised by the lawsuit in Virginia. As you recall, on August 3rd, Missouri voters passed 71% the Proposition C, which was a rejection of the federal health care mandate. And Proposition C states that no person, employer, or health care provider shall be compelled to participate in a health care program. This was Missouri's way of saying we are not going to participate in this mandate. And the Missouri bishops remained neutral on the mandate. They felt that Catholics of good conscience could differ on whether a mandate was a good thing or not, and whether it was appropriate. Some would argue that the only way for more people to be insured is for everyone to be required to purchase insurance so that the insurance companies can afford to insure more people. And so there was a sense that for purposes of obtaining universal coverage, that the mandate for some Catholics might be seen as a good thing. On the other hand, they felt that there was no conscience protection in the law that would allow people to opt out of being part of this mandate, and particularly a mandate that requires them to participate in a health insurance program that includes abortion and fails to protect conscience. And so they felt that Catholics could differ on whether they were supporting a mandate. And they also felt that there might be some political issue involved here. They understand that if the federal courts uphold the insurance mandate, that Proposition C is going to have no legally binding effect. And so they felt that they would remain neutral on this issue, given that Catholics of good conscience can differ as to whether the mandate itself was a good thing. So in Missouri, we also have passed Senate Bill 793 this past session, where we provided that there will be no abortion coverage in the health insurance exchanges. And this was something that we owe a lot of gratitude to our citizen network for helping us get this passed. And Missouri was actually only one of 4 states to opt out of the abortion within the health insurance exchanges at this point. Those states that also joined were Arizona, Louisiana, Michigan, and Tennessee. The other thing that we learned through the course of the debate this past session was that the Missouri community health centers have not performed abortion in the past and do not intend to perform abortion in the future. And Joe Perley, who is the CEO of the Missouri Primary Care Association and who is in charge of the Missouri community health centers, has sent a letter to the Missouri legislature saying the Missouri community health centers do not perform abortions. They don't do them, and they haven't done them in the past. They're not planning to do them in the future. And so he wanted the legislature to know that that was not a concern in Missouri. As most of you know, 95% of the abortions that take place in Missouri occur at the Planned Parenthood facilities in St. Louis and in Columbia, and the community health centers are not presently performing abortions in Missouri. So what else can we do at this point, given what Missouri has already done to address the health care bill? Well, as we discussed, the problems with the bill have to be corrected with congressional action. There's no way for the states to fix this bill on their own. We pretty much have done everything we can do in Missouri to try to insulate Missouri from being affected by the abortion provisions in the law. But really, congressional action is needed to fix the concerns that are still present in the law. And 2 federal bills have been filed to date. The first one was H.R. 5111. It was filed in April. And the second is H.R. 5939. It was filed in July. On May 20th, the USCCB, actually after H.R. 5111 was filed, the USCCB issued a statement urging Congress to fix the abortion and conscience problems in the law, and they specifically referenced H.R. 5111 and asked Congress to support that bill. They also issued a statement dated May 21st of 2010 in which they wanted to clarify their position with regard to the debate, because there was some question at the end of the debate as to whether the bishops were actually supporting the bill in light of the executive order. In their statement on May 21st, they wanted to make it clear that the bishops will never conclude that they must accept what is intrinsically evil so that some good may be achieved. And this was a statement issued by Cardinal Daniel DiNardo, and he wanted to go on the record in making clear that the bishops did not support the health care bill with the executive order, even though they felt that health care reform is a good thing and that this bill would provide more coverage to more Americans. They did not want anyone to think that they were willing to accept that with the abortion problems that were part of the bill. So they did not feel that they can accept an intrinsic evil in order to get a good, which I think is pretty consistent with Catholic teaching. The H.R. 5111 was sponsored by Republican Pitts. He's a Republican from Pennsylvania. And that bill is an amendment to the health care bill. He's got 124 co-sponsors at this point, including, I know, at least a dozen or so Democrats that are also joining in this fixed bill. And the bill provides basically that no federal dollars will be used for abortion or insurance that covers abortion. It also provides that insurance companies that offer abortion coverage must also offer an identical plan that does not cover abortion. So that would fix the problem with the bills that people had to purchase with abortion coverage in it and being forced to pay a separate premium for other people's abortions when they didn't want to. This way, those insurance companies would be required to provide a plan both with and without abortion coverage. It also states that if abortion services are offered, no federal dollars will be used to pay the premiums for those plans, and that no state conscience laws will be preempted, as we discussed. It fixes that loophole. It also fixes the loophole which would allow government to discriminate against doctors who refuse to participate in abortion procedures. As I mentioned, the USCCB has supported this bill and offered their support of it, and have asked that Congress pass this bill to fix the problems with the health care bill. H.R. 5939 is a bill that was sponsored by Representative Smith from New Jersey. His bill is called the No Taxpayer Funding for Abortion Act. It's not an actual fix to the health care bill. It's actually a standalone bill. And what his bill would do is basically codify and make permanent the Hyde and Weldon amendments so that they are a permanent part of American law. He at this time has 174 co-sponsors, and again, I'm sure that the same Democrats have signed on with his bill. Although his bill is a little bit different, I think his bill sort of assumes that if Republicans take control of the House or the Senate, that they might try to repeal the health care bill, and that this would then be a permanent fix to the abortion problem, making Hyde and Weldon permanent law. So we'll see what happens in the next election and what takes place with regard to these two bills. But his bill is very similar to H.R. 51 with regard to the abortion and conscience protection, that it would address the problems in the health care bill. Again, it would just make them a permanent part of the law. It also would provide that federal health care centers may not perform abortions. This is to address the abortions on the military basis that we've been hearing about so much in the news lately. So what else you can do is you can inform yourself. Read the bills. If you want to know what is wrong with the health care bill, rather than spending the hours that you would need to spend reading the 100 or 200 pages relating to abortion, you can read H.R. 5111 and H.R. 5939. Those two bills would really kind of point out to you what's wrong with the bill. They're 2 or 3 pages long and a lot simpler to get through. You can also look on those bills to see if your congressman or congresswoman has signed off as a co-sponsor of that bill. and if not, you can contact them and ask them to support